Thank you, Dr. Pauling, and I want to thank Tri-State Indivisible for putting this event on tonight. It's always an honor to be included in these sorts of events. Certainly, it's nice to share the stage here with some of my friends and colleagues here in West Virginia. Always an honor to share a stage with a national expert like Mr. Fieldman here. Now, like Dr. Pauling said, I am from the American Civil Liberties Union, and the ACLU does oppose using Article 5 Convention of States as a way of amending the U.S. Constitution. Our concern, like that of most other organizations that oppose this, is primarily that of a runaway convention. However, maybe different than other organizations that would oppose this, the ACLU also sided with Citizens United in that 2010 case, Citizens United versus Federal Election Commission, which is one of the major genesis points for this whole debate and for this whole controversy. Now, Dr. Pong also said that I did go to law school. I spent some time practicing as a lawyer. I don't practice anymore. One of the things that I did learn during that process, though, is you always want to lead with your strongest argument, and you never want to concede any points you don't have to. So what I want to do right now is break both of those rules. And this probably explains why I'm not practicing attorney. So again, the ACLU did side with Citizens United. It's one of our more controversial decisions. Certainly the ACLU has a history of taking controversial positions. In our past, we've represented the Klan, we've represented neo-Nazis, we've even represented NAMBLA. I think I see a few confused faces. If you don't know what NAMBLA is, do not Google it. I promise you it's not worth it. Okay. But I'll tell you, listen, in my personal experience, the case that we get the most negative attention for, the case we get the most flack for, is Citizens United. So I do recognize that it is a really controversial decision. But I think it's important that you understand three major points from me tonight. The first point is that there is a legal debate over the safety of an Article 5 convention. It is not a settled matter, and you need to understand that. The second point that you really need to understand is that any amendment is not going to do what we want it to do. We're not going to be able to adequately control the things we want to control with an amendment. The third thing we need to understand is that we don't even need an amendment to achieve the goals that we want, and there's already proof out there that we don't need that. So, one of the things, to explain this a little bit more, one of the things that I find really frustrating, really odious, really reprehensible, frankly, about modern political discourse right now is this tactic that I call the merchant of doubt tactic. Some of you may already know what I'm talking about when I say that, but for anyone who's not familiar, the idea is we can't have real policy debates because one side will go in and disagree with the underlying understanding rather than get to the policy debate. So to explain this a little bit further, Big Tobacco sent in people with medical credentials, with scientific credentials, long after the medical community had acknowledged that smoking and tobacco was causing lung cancer, was causing heart disease, was causing lung disease. But we couldn't figure out how to regulate tobacco because we were still having to debate that science long after it was already settled. Similarly, we see the same thing with climate change now. We recognize that science has already recognized that climate change is happening, it's caused by humans. But we're still having to debate that underlying principle rather than the policies that we might be using to achieve it. Now, the reason I tell you I dislike this tactic so much is because what I'm going to be saying tonight is going to sound an awful lot like it. And I want to distinguish my arguments from those arguments. Because there is not actually a genuine debate. Here there is a genuine bona fide debate. A court has never heard a case over whether a Convention of the States under Article 5 can be limited. All of these issues have to be settled somehow. And in fact, the typical way that a debate about an Article 5 Convention of the States goes, whether it's on a stage like this, whether it's in academic journals or legal journals, or where I'm most familiar with it, which is in a state legislature, is both sides will bring out their Supreme Court justices, their legal opinions, their scholarly journal articles, their organizations that support this method. And they'll both say, hey, look, either this is a safe method, it can be limited, those limits can be enforced, even if something did go awry, we've still got the 38 state ratification threshold. This is safe, we can go ahead and do it. Or on the other side, this isn't safe, we don't know that it can be limited. Again, we don't know if we can enforce limits, and that 38 state ratification threshold is not as safe as you think it is. But both sides will trot out those experts. And the fact that that's the debate, that it's legal experts on both sides, proves to us that there is not any established precedent here, that we don't actually know. And that's something that's really important to understand because we're talking about potentially fundamentally changing the U.S. Constitution and basic rights. We should be extremely cautious about it. In fact, when you go and you read the scholarly journals and the articles supporting an Article 5 convention, they acknowledge that either Congress has to pass rules ahead of time And again, the whole reason we would be using this method is because we don't trust Congress. So it certainly doesn't make sense for Congress to be the one setting the rules for it. Or courts would have to come in to decide what's allowed and what isn't allowed. They'd have to be there as the arbiters, the regulators of this. Now, I'll tell you, the purpose of the courts is to settle disputes over fact and law. Here it's not a factual dispute. We're not saying he said, she said. These are legal disputes. We don't know. We'd have to rely on the courts to settle it. And when it's something, again, as fundamental as the U.S. Constitution, if the issue is so much in debate that it has to go to court to be settled, it is not something we should be risking. That is not a risk we should be taking with the U.S. Constitution. Now, I also said I want to concede a point. The point I want to concede here is money in politics is a problem. It's absolutely a problem. Money in politics is corrupting. It gives the appearance of corruption. It means that special interests get too much attention. It diminishes trust in the system. Yes, it would be a problem. It would be ludicrous for me to speak here tonight and say that money in politics is not a problem. However, an amendment is not going to fix it. One of the things, again, when we look at the business world, when we're looking at businesses and regulations, we often see that regulations that are targeting big businesses that may be major polluters or maybe major violators of consumer rights and consumer protections, we create new regulations for those businesses, and they have teams of lawyers, they've got teams of marketers, they've got political influence. They'll go out and they'll find workarounds, they'll find loopholes, they'll be able to circumvent any regulation we put out there, and they continue to engage in the bad behavior. And what winds up happening is smaller businesses, medium-sized businesses even, are squeezed out of the market by an increasingly complex set of regulations that they can't comply with. So the people we're really targeting with regulations and rules aren't held accountable, and everyone else is squeezed out. And the same thing would happen with something like this. If we try to limit the influence of money in politics, moneyed interests are going to find ways to work around it. They've got the tools, they've got the resources. They may even be willing to accept a fine to just go out and violate the rules, because they may decide that that's worth it. And at the same time, smaller businesses, maybe even nonprofits, because most nonprofits are technically corporations, associations of citizens may be squeezed out by these tighter rules. Now, if we do manage to find an amendment that's going to be set up in such a way that we aren't going to, that there aren't going to be workarounds or loopholes, the chances are it's going to violate First Amendment rights in some other way. We're going to violate free speech in some other way, and we're also going to be limiting speech in a way we should be extremely concerned about. Now, again, the last point I want to make in all this is we don't actually need this. So in 2015 and 2016, we saw Bernie Sanders run a nationwide campaign, primary campaign, based on small dollar donors, rejecting corporate money without a lot of help of PACs, potentially even working against the political party he was proposing to run for. And even though he fell a little bit short, he still came up runner-up in a massive election. And what we've seen now in 2018, just a few years later, is across the country, at every level, local school boards all the way up to congressional candidates, people are adopting this model, and they've had success. They've already won primaries. Some of them are likely to win their elections, not in spite of using this model of rejecting big dollar donors, but because of it. And what that shows is that what we need more than any amendment, more than any law, is we need an engaged citizenship who's paying attention to where the money's actually coming from, who's paying attention to votes, who's paying attention to what's going on here, who recognizes that oftentimes the loudest and most moneyed voice in the room is the one least concerned with everyday interests. And until we actually have that recognition from our public, no amendment, no law we change is going to actually have the effect we want. So again, that's what I think people need to understand when we go through this. One, there is an actual legal dispute. It is not settled law that this convention is safe, and we're talking about risking something as basic and as fundamental as our constitutional protections. We should be careful. Two, an amendment will not do what we want. And three, finally, again, we already know that we don't need it to achieve our goals anyway. Thank you.